Hello, this is a presentation of Family First Legal. Today we will be doing an overview of custody in Maryland. Today's overview will look specifically at parents who are trying to obtain custody or who are involved in a custody case. We will look at the standard the court will use to determine which parent should have certain custody rights, and we will look at the factors that are used to determine if either parent has met the standard. So first thing you should know is that generally there is a presumption in Maryland that the parents of a child are both custodians of that child, with neither of them having a greater right to custody than the other. This will be the status quo or the standard the court will consider anytime there are two parents to a child, that you start off on equal footing. Now, the equal footing will change based on the standard and the factors that you use to meet that standard. So we'll get more into those in just a moment. But before we get there, you need to think about whether you are a parent and who can be a parent. If there are two people who are married at the time a child is born, even if they weren't married at the time the child was conceived, those two people will be presumed to be the parents of that child. That means they start off on equal footing, having the same custodial rights. A child born to unmarried persons shall be presumed as follows: that the mother will be presumed to have custodian rights as the mother. However, the father will not be presumed to have custodian rights unless he has judicially been determined to be the father has acknowledged the child as his in a writing, the father has openly claimed the child to be his own, or the father subsequently marries the mother and claims the child. Now, this may also apply in same sex marriages, but I like to address same sex marriages when we talk about de facto parents. And so you may want to watch that video as well. Another way that someone might be declared to be a parent, and that also may include de facto parent, is that the person has been judicially recognized as a parent of the child, like an adoptive parent. Now, the standard the court will use to determine whether someone has met their burden to prove that a certain custodial arrangement should be made for the child is the best interest of the child standard. That standard basically says that any parent who is in dispute over physical and legal custody arrangements must provide substantial evidence to the court that the desired custody arrangement is in the best interest of the child. The court will weigh these best interest factors to determine what parenting time arrangement will be in the best interest of the child. So now how do you reach this standard? The way that you reach the standard is by proving more factors in your favor and more factors out of the favor of the other parent. In other words, so if you're asking for a particular parenting plan that you have primary or sole custody, then you have to show factors that are positive in the direction for yourself and not so positive in the direction for the other parent. This is not about throwing mud at one party or the other, but it is about identifying the issues that might arise in showing the best interest of the child. So let's look at a few of those factors. Some of those factors will pertain mostly to the parent and others will pertain to the child. But these factors are not conclusive by themselves. So don't take one factor and think that you have won your case. You have to be able to prove that multiple of these factors exist for your plan and against the other party's plan in order to show best interest standard has been met. So for instance, the fitness of parent. If you're trying to prove that the child should be with you full time, then you'll have to show how you are a fit and proper parent to care for that child. There's no substance abuse issues. You have no issues of abuse of an adult or abuse of a child in your past. Your criminal history doesn't put you in a position where you or might have to be away from your child for long periods of time due to incarceration, things like that. But on the other end of the spectrum, if you're trying to prove that the other party doesn't need that, doesn't is not fit, does not meet the fitness of the parent test, then you will have to show that that party is actually not fit in that they are abusive or that they are using drugs or exposing your child to drugs, that they've had some behaviors in the past that show them to be an unfit parent, not knowing how to parent a child, yelling back at the child instead of trying to meet the child's need at an inappropriate age. For instance, yelling at a 2-month-old to stop crying over and over again, and doing this even after and against advice might be considered as one factor. Now, this again is one factor among many. Character and reputation of the parties, the sincerity of the parent in their request. So, when we're talking about sincerity of a parent in their request, we're looking at whether that parent is really wanting the custody of the child, or if they're trying to get something else accomplished by seeking custody or disputing custody of the child. So, that might happen most commonly when one parent has now been told they have to pay child support. They haven't had contact with the child or have had rare contact with the child. And in those situations, the court may be able to look at that as in how sincere are you about having this contact with your child? You didn't want contact with the child prior to having to pay child support. Now you're saying I want that contact. Now the court's not going to look at this necessarily by itself, but this, in conjunction with all the other factors, will have an impact on what the court decides. So, does each parent have the ability to maintain the child's relationship with the other parent or other relatives on each side of the family? That will be another factor. The financial status of parents, while it's not conclusive, it is something for the court to consider. Is this parent financially able to care for this child if they're able to get the custodial arrangement they have? The demands of that parent's employment. If you're working 80 hours a week, when are you going to have time for your child? And what is the plan for that child to be in the care of a parent? That can be a factor to address best interest standard. The ability of the parent to meet the child's needs. So if the child has special needs or things that need to be addressed, or even someone to be there for that child after school, and one parent's not able to meet that, or one parent is, that can be a factor as well. So when we're looking at child factors, they're very similar to the parent factors, or you'll see they're kind of the opposite side of the coin. Because when you're talking about the parent's ability to meet the child's need, you have to know what age the child is. Maybe they're very appropriate with a teenage child, but they're using teenage parenting skills with a child who is much younger, and therefore they may be inappropriate for that child because that child's lack of understanding won't allow them to understand like a teenager. So it could be the age of the child, or it could even be the developmental needs of that child that are in question here. And certain children have, even if development is within the normal spectrum, they may still have educational issues that need to be addressed, and which parent is best equipped to do it, either because of the amount of time they can spend with the child, the amount of financial resources they can use towards it, or because of their understanding of the educational needs. And then the court's going to look at the preference of the child once the child reaches a certain age. Now, courts have looked at the preference of a child as young as a 7 year old or 6 year old, but that's usually a rare case. Usually, you're going to be looking at more towards the preference of a child when you start getting into those teenage years, like 15, 16, and so on, to determine what that child might prefer. Because you're going to have a hard time forcing the child into a certain arrangement if they are old enough to make decisions and they don't feel like that arrangement fits them. So the court may want to hear from that child, to know what that child desires. So these are just some of the factors. There may be others, and if there are other things specific in your situation that you feel like would be a factor that shows the best interest of the child, definitely include that in your complaint or your response to a complaint for custody. Now, this has been a general overview of custody between parents. If you are interested in finding out more information for your situation, or you feel like your situation wasn't quite addressed here, you may want to call us to get a free consultation. Again, we are Family First Legal. You can reach us at 240-734-1024, or you can look at our website at www.fflmd.com for more information. And if you're on that page, you might want to go to our Contact Us page to schedule your free consultation online. All right, look forward to hearing from you in the future. Good luck with your endeavors. Thank you.